Look at me now and how's the frown? Holding my breath, but I'm on the ground. Taking the kicks, but it's breaking me down. The only reason saying is making the sound and cooking the meal and fill up the seal and out on the ice and living this life. Just holding my ground and making the sound. Just getting my ride and looking for life. Out on the Nuna ice as well. Out with friends, many stories to tell. Out with the family, stories as well. Some may ask, but we know what's real. We know who we are, we know where we're from. All the way dark, 24 sun. 7 days a week, I'm gonna stay strong. All from inside within you, that pride. 'Cause I live the life, and this is my home. Tiki up, Point Hope. I'm so proud to be in your path. 'Cause I live the life, and this is my home. Tiki up, Point Hope. I'm so proud to be in your path.
For thousands of years, Alaska Native people thrived in one of the harshest yet richest lands in the world, the place we now call Alaska. The many diverse cultures had highly developed relationships with the land and the natural resources upon it. Social ties were strong and organized through clans.
In the clans, there's a self-governance structure built into the clans. And every clan has an extremely defined and very sharp sense of where governance of the people is and where the sacred is.
The laws that were given to us by our ancestors, the old people, the traditional laws of how things should be. What you should do when you catch your first whale, what your first animal of anything, how you behave in the community. They had a set law already in place. It was about sharing, about gathering, about feasting.
Since time immemorial, land has always been central to the lives of all Alaska's indigenous cultures.
I come from the native village of Tanacross. My spirit is there. All the lakes and streams, and the rivers, and the mountains, the hills, the trees and animals, I have a relationship with them. My people developed religious protocol processes centuries, and I still practice that.
The land for the Alaska Native people has a significant value in their cultures. There's a spiritual tie to the land. And not only that, but the physical attachment to the land is that we live on and off the land and from the land and waters around us.
Alaska Native people have seen 2 centuries of changes to their culture and legal standing. Today, there are approximately 100,000 Alaska Natives living in the state. This is the story of their legal and political history.
Mattum nastayud ka kaisin yud Alaska Nimani mattum aurksutsa.
Kasaga te Alaska man kangekusina.
Showing great zeal not only in your spiritual labors as a novice, but also in your apostolic fervor, as you preach to the people sitting in darkness, you, O venerable Herman, revealed the light of Christ to them with great power.
Russian explorers were the first Europeans to arrive in Alaska, sailing across the Bering Sea. Upon discovering the richness of furs, they came in increasing numbers.
Originally, it wasn't to conquest or conquer. They were typical businessmen. They were coming to to make money, get furs, take it back, sell it, and become rich. I mean, they were looking for their gold, which is in sea otter furs. And so originally they started coming over here from 1741
The Russians established their major settlements primarily on the Alaska coast.
During the Russian period from 1784 to 1867, especially here in Kodiak, we were pretty heavily devastated, and primarily within the first 20 years. Subsequently, from 1767 on all the way up until 1867, when they finally sold Alaska. You know, they took over, and the way they did it, and it was pretty brutal.
Many died through the introduction of new diseases, and men were forced to hunt for furs, which did not allow them enough time to provide food for their families. Today, geographical names and the Russian Orthodox Church are reminders of the Russian period in Alaska's history.
When one looks at the history of Alaska, one looks at truly the American native people who were here even before the Russians came. When the Russian church wanted to evangelize this part of Russia in the late 1700s, so it came not to make Alaska Russian, but to make it authentically Orthodox within the culture in which it lived. It is an indigenous, Orthodox, Christian parish family of native people and then some American converts.
With the long distances involved, business in Alaska was difficult for the Russians, and the opportunity presented itself to sell their interest to the United States for $7.2 million.
The United States acquired Russia's interest in Alaska through the Treaty of Cession of 1867. It's often said that there are no treaties with the Alaska Natives because in 1871, a few years after the Treaty of Cession, the Congress prohibited treaties with Native Indian tribes. And that's true, there are no treaties with the Alaska Natives, but there is a treaty about them, and that is the Treaty of Cession. And Article 3 of the treaty divides the people in Alaska into two groups. The inhabitants, who reserve their allegiance to Russia, were able to either go back to Russia or be admitted automatically as citizens of the United States. And the other group, or group of people, was the uncivilized native tribes. And the uncivilized native tribes were to be subject to the laws applicable to the to the aboriginal tribes of the United States, and that's almost verbatim the language of Article 3. Article 3 mentions tribes 3 times, so it is pretty clear that the United States acknowledged at the time of the Treaty of Cession that there were tribes in Alaska and that they would be subject to the same laws applicable to the tribes, the aboriginal tribes of the United States.
At first, Alaska was under military rule with little interest from the federal government in the newly acquired land. But as Alaska's population increased with people coming in search of gold, the federal government began to take more notice. Congress provided a small measure of civilian government through the Organic Act of 1884, creating the District of Alaska and assigning it some federal administrators, a district court, and a school system. Sheldon Jackson was appointed to be the General Agent of Education in Alaska.
Sheldon Jackson, who was affiliated with the Presbyterian Church originally, saw that there was a need for many teachers in far-flung villages that were not being served directly by the government. So he set about recruiting teacher missionaries from many different religious sects. That's why we see in Alaska today people of the Moravian persuasion, Quakers up in the Kotzebue area, and many others. Of course, there was the Russian Orthodox already in place.
Sheldon Jackson actually then began to create a very similar structure as existed in the lower 48, with reservations of some kind, small or large, and focused on assimilative education through schools and these other activities that he promoted.
The schools were notorious for prohibiting children from speaking their native language, which had a lasting effect on the loss of language and damage to the native culture. But it was the funding specifically for the education of Alaska Native people that set the stage for tribal status in Alaska.
Year after year, appropriations were given to the Nelson Act for the education of Alaska Natives, and it really is one of the foundation stones of the trust responsibility towards Alaska Natives and the special, unique relationship between the United States government and the Aboriginal inhabitants of Alaska.
It was primarily under the direction of the missionary teachers that councils were formed in the villages as local governments.
From their side, the indigenous population, the Alaska Natives, peopled these councils with people they trusted in the sense of their clan leadership, their umeliks, the people who were in charge of subsistence activities. And so it was essentially a use of traditional leadership and family leadership and repackaged in something new called the Village Council. They were dealing with the matters pertaining to the school, yes. They were dealing over time with matters pertaining to the U.S. Commissioners as they entered the landscape and the U.S. Marshals. And they were looked upon as the go-to group by all of these outside authority figures.
As the discoveries of new goldfields brought people to Alaska in droves, Congress began the process of moving land into private ownership. Disputes over land, particularly between miners, resource developers, and Alaska Native people, arose, and a string of court cases concerning Alaska Native land rights began. There were contradictory decisions in these court cases, but one decision clearly indicated that Alaska Native people had an aboriginal claim to land which only the United States government could settle.
So in 1905, Territorial Judge Wickersham issued a decision in United States versus Berrigan, where he basically applied the foundations of federal Indian law to Alaska and brought the reasoning of Johnson versus McIntosh and Worcester versus Georgian and all of the Justice Marshall trilogy to Alaska, and found that Alaska Natives could not pass on private title to land, that the federal government had a trust responsibility for the territory of Alaska, and that you would need to negotiate with the federal government if you wanted to derive any rights to native lands. And so it basically brought federal Indian law to Alaska.
The year after the Berrigan decision, Congress passed the Alaska Native Allotment Act in an attempt to get land into ownership by individual Alaska Natives.
It did provide for heads of family to apply for up to 160 acres of individual-owned land here in Alaska, and it was, if the application was successful, the native received land in what's called restricted fee title, which places a lot of restrictions on the ability to use and to alienate the land, and the federal government is heavily involved in the oversight of native allotments to make sure that the owners of the allotment are not taken advantage of. And so it's another statute and another way that the federal government maintains its trust responsibility to Alaska Natives.
With limited knowledge of the English language and no one to explain the law, many Alaska Natives were not able to get allotments. 20 years later, Congress continued the process of getting land into public and private ownership through various townsite programs, one of which was unique to Alaska Natives.
In 1926, Congress passed the Alaska Native Townsite Act. That act allowed Native individuals in Alaska to apply for title in restricted status. That restricted status has the same protections and restrictions found in native allotments. Over the course of the program, there were 130 federal town sites created in Alaska. In those 130 federal town sites, the trustees issued approximately 4,000 native restricted deeds.
While in the early part of the 20th century in Alaska, there were some efforts to get land into native ownership, millions of acres of Indian lands in the lower 48 were being lost through various acts of assimilation, such as the General Allotment Act of 1887. Under the presidency of Franklin Roosevelt and his New Deal platform, Congress adopted legislation to halt the loss of land and to promote tribal governments through recognition of tribal constitutions that were voted on by the tribal membership.
The Indian Reorganization Act of 1934 marked a fundamental change in American Indian policy from assimilation and to eliminating Indian reservations to consolidating them and recovering the lands that had and preventing further allotment of lands. But it also permitted native tribes to organize under the IRA with federally approved constitutions and charters. Now, when it was originally adopted, it included Alaska, but it omitted a couple of key sections. They amended the 1934 IRA in 1936 to specifically apply to the Alaska Natives. The other provision of the IRA is applied to Alaska. Section 2 specifically allowed for the establishment of reservations in Alaska that would be IRA reservations that were, I think, intended to be a means of settling these Aboriginal claims of use and occupancy. But the creation of reservations in Alaska on that scale, these were large reservations of 1.4 million acres in the case of Venati, for example, and others that were close to fishing grounds that included fishing waters, were very controversial, to say the least. And then World War II came along, and the whole project kind of ran into political trouble.
Work on organizing Alaska villages under the IRA halted, and the federal government's primary concern in Alaska was its strategic military location and resources. The Alcan Highway was constructed to gain easier access to Alaska. In response to the Japanese aggression in the Aleutians, the Aleut people of the Pribilof and Aleutian Islands were removed from their homes and were relocated in internment camps in southeast Alaska for years. The conditions in the camps were horrendous, and many died. Dylan S. Meyer was the director of the War Relocation Authority at the time. Ironically, after the war, he was made Commissioner of Indian Affairs during the 1950s, the era of tribal termination. After the war ended, Congress again looked at legislation regarding Indians and passed a statute in 1948 defining Indian country, the territorial area over which a tribe has jurisdiction, the ability to make and enforce its laws. Lands considered to be Indian country are reservations, allotments, and dependent Indian communities. Congress continued to make Indian policy in the 1950s, which is called the termination era, because Congress adopted policies aimed at terminating federal obligations to tribes. No tribes in Alaska were terminated, but a law called Public Law 280 was applied to Alaska, which extended state jurisdiction into Indian country, and Alaska experienced the relocation of many Alaska Native people to cities in the lower 48. In addition to relocation, many were sent to boarding schools.
My parents, when they went to school, they were gone. You know, they didn't have money to send them back. Some of them stayed 3-4 years before they came back home. You know, and this is the issue of speaking the language, losing the language, forced to speak a different language that you didn't even understand, and them coming back to their villages from living in a totally Western way of life and coming back to their home place and kind of being lost in a way.
In the the 1950s, two major projects with potentially enormous impacts on Alaska lands were proposed. The construction of the Rampart Dam on the Yukon River that would have created a gigantic lake, and Project Chariot, a plan to explode 5 atomic bombs at Point Hope to create an artificial harbor.
They wanted to build a deep water harbor for commercial use. They were looking at an atomic bomb explosion, and like a nuclear bomb, I guess. But they had a plot ready that they wanted to do. They drilled the holes. They had it ready. So they came to Point Hope. They had their town meeting, and the Point Hope people said no. There was a lot of people angry. People that were normally quiet went out and spoke against it, because they were threatening their way of life.
Federal government nay chan kun thon cha koram tai ku shakti han ko kui ai.
The status of Alaska went from military rule after purchase to a district in 1884, to a territory in 1912, and finally to achieving statehood in 1959. The Statehood Act itself did nothing to clarify what Aboriginal claims Alaska Native people had, but the impacts of statehood were very significant, both on Alaska Native governments and on the land. The new state was entitled to select 103 million acres, and it began to select the best lands, lands in and around villages, and lands used for subsistence, which was very alarming to the Alaska Native people. They filed administrative protests to state land transfers, petitioned to establish reservations, brought lawsuits, and in 1966 organized the Alaska Federation of Natives with the intent to achieve the passage of a fair settlement. That same year, one of the principal recommendations of the new federation was realized. Secretary of Interior Stuart Udall exercised the federal trust responsibility to Native peoples by imposing a freeze on all land selections in Alaska until Native land claims were resolved.
The Secretary had declared a land freeze, and one of the real issues, of course, was oil. Pipeline. Stevens Village was the main focus of the oil companies because they had the pipeline corridor blocked off with their claims. And so the oil companies were putting a lot of pressure on Congress to settle.
With the land freeze in place, the discovery of North America's largest oil field at Prudhoe Bay became the ramrod for settling the Alaska Native land claims. The claims had to be settled and the land freeze lifted before the pipeline could be built. Alaska Native leaders lobbied hard for a fair settlement of their claims.
Our lobbying effort was probably one of the best organized that Washington had ever seen. Not because we all thought alike, but because we organized ourselves. We went and met every morning and determined who we were going to see, who was going to do it. Of course, we all had our own story, and so we'd go talk to the senators and congressmen, and I can remember one senator, when Willie Hensley and I went to see him. He asked us, he says, "Are you gentlemen lawyers?" I said, "No, we just believe in what we're doing, Of course, the basic premise of the AFN was 40 million acres was the minimum that we were going to accept. We wanted X dollars. We really hadn't decided, but we wanted, one of the things we asked for, but we did not get, was a royalty on all of the oil exploration and oil funds that were being pumped out of Alaska. So, but that didn't happen. But we got in the final bill was $962.5 million, which was a fair sum back then. Alaska land claim khani chatilait takul malhut illait tawam bimafknat.
On December 18, 1971, Alaska Native Aboriginal claims were settled and extinguished by an act of Congress and signed by President Nixon through the Alaska Native Claims Settlement Act, which is often referred to as ANCSA, the largest land claims settlement in U.S. history. Some called it an experiment. Others declared it to be an act of assimilation or even termination. But all would agree that the implementation of ANCSA is very complex.
ANCSA did primarily two things. It established corporations to take the land that was the basis of the Aboriginal land claims, and the second thing it did was it transferred money from the federal government to those corporations so that the corporations could do economic development, business development.
The most common pattern of land selection was for the village corporations to select core township lands around the villages. The village and regional corporations selected lands around the perimeter, alternating townships to create a checkerboard pattern. The village corporations owned the surface estate to their lands, while the regional corporations owned the subsurface of the village corporation lands.
Pursuant to the Alaska Native Claims Settlement Act, the Alaska Natives were told that they must now own part of the land that was there for their use. That had a very profound impact upon the Yupik elders because they grew up as land users rather than landowners. And in educating our elders about the mandates of land selections, what was very difficult for us to explain is that they must now own a piece of that land that they have always used for livelihood. So the concept of land ownership as seen in the Western world is absent in the Yupik society. So this was a very, very profound change in the minds of our elders dealing with land.
ANCSA has been amended many times, it turns out, over the years to do a variety of things, some important, some technical, but one of the most important sets of amendments actually happened in 1991. And that did some very important things that were fundamental to the Act. The first thing it did was it extended some of the alienation and land protections that were written into the original ANCSA. And the second thing it did was it gave the corporations the option to enroll descendants as new shareholders.
Originally, only Alaska Native people who were alive on December 17, 1971 were shareholders in Alaska Native corporations. You have to be a shareholder in order to receive dividends and to have a voting voice in corporation business. After the 1991 amendments, some corporations voted to allow new shareholders in, but many Alaska Natives are not shareholders in any corporation.
When it comes to the issue of those born after 1971, the Alaska Native Claims Settlement Act amendments give opportunities for regions to include those born after that date, and it's incumbent upon people in those regions to deal with that.
ANCSA was a complex piece of legislation that had many impacts on Alaska lands. It extinguished all reservations in Alaska with the exception of Metlakatla. It also involved land exchanges, easements, land protection issues, and requirements for village corporation reconveyance of land to individuals, businesses, and for community development through Section 14C of the Act. The Alaska Native corporations have seen some business failures, particularly in the early days after ANCSA passed, but most have worked through them to become successful business organizations.
The ANCSA corporations are probably in almost every conceivable line of business, but they're certainly in a number of notable areas. They own construction and oil field services businesses. They're in land and resource development. They're in real estate development. They're investors in sophisticated investment funds. They are in aerospace and missile defense, large variety of services businesses to the United States government, hospitality and tourism, environmental remediation. If you can name a line of business other than heavy manufacturing, probably, ANCSA corporations are involved at some level.
We have companies ranging from ownership of hotels all the way to a cable company that lays cable, and a project that we're working on here locally is establishing a microwave system so that we have real-time internet in the village.
In addition to the profit-making businesses, many of the corporations are actively involved in the establishment and support of nonprofit affiliates like educational foundations and other social services.
These are all Native institutions that were created decades ago by some of our more visionary elders at this point. And they recognized that the wholly tribal model in the lower 48 was unsuccessful in many cases. And so they wanted to try something different. And what was different was this grand social experiment called ANCSA. And so we established corporations to take land and do the business and economic development component.
What ANCSA did in 1971 was recreate or recast tribal members in a light that nobody had expected or seen or foreseen. So the emotional part is that it gives credence to people who adapt to Western ways of thinking. It legitimizes Western thought process in the tribal community, and that's an emotional subject because that's all about identity, I guess you would call it standing.
Now what's different about this settlement from the lower 48 settlements, reservation kinds of settlements, you have a similar sort of dynamic. The native tribal claim to Aboriginal title is extinguished, and some land is reserved for a tribe, for a political institution, a community, from which you get the word reserve or reservation. And the political institution, the tribe, retains that land as well as the right to the property and the authority to govern the land in the reservation settlement. In Alaska, the contrast is that the tribes had their land claims extinguished, but the land that would have been reserved for the tribes went to another institution, the regional corporations or the village corporation. And the tribal government then had no territorial base upon which to associate its jurisdiction, its political jurisdiction. And that set in motion several things. I mean, the Claims Act set in motion several things that were issues and resolution of issues that must not have been anticipated at the time. One of them was the scope of, existence of, and scope of tribes and their jurisdiction. And the other was the unresolved issue, even though it was purportedly extinguished, of hunting and fishing rights. And both of those issues play out from 1971 to the present, and will probably be played out for decades to come.
Narazi Sukare and Kushet Ayekorantai.
Chinook is extremely important to the people of the Lower Yukon. It provides them food. It provides them with the ability to feed their families throughout the cold winters. It gives them energy when they conduct their winter subsistence activities.
The Alaska Native culture, economy, and traditional way of life are intimately tied to living off the land, gathering, hunting, and fishing for food. This way of life is now called subsistence in the legal and political arenas.
When my own people refer to subsistence, we don't refer to it as shooting or killing or taking or getting. It's generally about sharing, and it's most definitely all about learning to use what's on the land. So it's really all about learning how to deal with the resource that you've been given in order to keep the clan or the tribe healthy. It has almost nothing to do with taking or getting.
I'm so grateful that to say that my community is one of the oldest whaling communities where we still practice our whaling ways of life that was God-given to us thousands of years ago.
The subsistence story, at least part of it in Alaska, starts with the Alaska Native Claims Settlement Act in '71. And that act extinguished Aboriginal hunting and fishing rights in Alaska, meaning in Alaska, all waters 3 miles out. And the Secretary of the Interior, in exchange for that extinguishment, promised that he would take care of Alaska Native hunting and fishing rights. village corporation lands were primarily selected for subsistence hunting and fishing. But as it turned out, the Secretary was unable to really keep that promise. So in the passage of the Alaska National Interest Lands Conservation Act, and NILCA, tied later that section, was the provision to fulfill the promise the Secretary had made, the unfulfilled promise in ANCSA. And ANILCA has a rural priority for Alaska Natives. The deal was, it started out to be a native priority. The state of Alaska came in and said, no, make it a rural priority. We won't be able to administer a native priority. And if you do, we'll administer our lands, all state lands, federal lands, and native lands for a subsistence priority. So, but the result of that was that in 1989, in the McDowell decision, the Alaska Supreme Court struck down the rural priority in ANILCA, taking the state out of compliance and out of management. The federal government took over and managed federal lands for subsistence, but state lands and Alaska Native Corporation lands were left to the state to manage. And so that's been a problem for the last 2 decades. The problem is that under state law, the state law is much weaker than ANILCA. It provides a priority for all Alaskan residents. It can't be a local priority. And so you have this crowding of subsistence lands by all Alaskans.
There is a complex web of laws and international treaties regarding fish and game management in Alaska. Many management regimes are happening all at once, making it difficult for tribes and regional corporations to keep up with all these issues. A direction that Alaska Natives are uniting around is consolidating hunting and fishing laws, changing the ANILCA law explicit for Alaska Natives, expanding co-management roles for Alaska Natives, and getting a subsistence priority on native lands.
It's hard for Alaska Natives, or I suspect any culture, to sustain its customary and traditional way of being when you're being managed by someone else.
The center of our lives is the animals that give themselves to us. The whale and the animals have always been the center of our lives. Without the animals, we wouldn't be who we are today.
If you have to break a law to be who you are, then the law itself can be termed to be wrong or not of any use. And that's, I think, the fundamental lesson of subsistence that where we are today.
My natunallini Alaska miwe arnqechtnun ilagat mit mannabitklugu.
During the 1970s, Alaska Native people were focused on organizing the corporations authorized under ANCSA and getting businesses underway. The federal government was fulfilling its trust responsibility to provide health, education, and other services for Alaska Native people, primarily through the Bureau of Indian Affairs and Indian Health Services. In 1975, Congress passed an act which profoundly changed the way services are delivered to American Indian and Alaska Native people.
One of the most important acts in the history of our people was the Public Law 93-638, the Indian Education and Self-Determination Act. That not only provided tribes and tribal governments to secure contracts, but it mandated that if they wanted to do a contract, then the government must get involved in the contract with them for the services.
At first, villages pooled their money for these services and funneled it through organizations such as the Tanana Chiefs Conference and the Association of Village Council Presidents. These nonprofit Native organizations can give Native preference in hiring. Over time, tribes themselves began to deliver many of these services.
After the Alaska Native Claims Settlement Act passed in 1971, it was clear that the federal government still had a trust responsibility to the Alaska Native people to provide certain services. What was not clear after the act passed was the status of Alaska tribes. Were they still federally recognized?
On the federal front, tribal status of Alaska Native tribes was confusing because on the federally recognized tribes list, Our tribes were listed as Alaska Native entities alongside Alaska Native corporations.
In the 1980s, tribes were very active in pursuing their tribal sovereignty. They were organizing under the Indian Reorganization Act. They were publishing alcohol ordinances in the Federal Register, organizing tribal courts to protect tribal children, and the tribal leaders were including Alaska tribes in legislation coming before Congress in any way they could.
The state of Alaska was resisting tribal recognition.
The Alaska Supreme Court in 1988 decided in the native village of Stevens versus Alaska Management and Planning that there were actually no tribes in Alaska besides Metlakatla and maybe a few others. In 1993, under the term of Assistant Secretary of Interior Ada Deer, the Department of Interior issued a federally recognized list which included Alaska Native tribes as tribes. Congress affirmed this list in the Tribal List Act so that Alaska Native tribes were formally given federal recognition.
Gaining formal recognition meant that Alaska tribes have sovereign governments.
In order for us to talk about tribal sovereignty, we have to define sovereignty, and sovereignty in its simplest terms is just the right of an identifiable group of people to govern themselves. And so when you bring in the tribal sovereignty, then we add the inherent right to govern themselves, meaning they've governed themselves from the beginning of time. And so that's where we advocate a lot of our rights, is because we have inherent sovereignty because we've governed ourselves from the beginning of time.
Tribes also get additional authorities from the federal government. We consider that delegated authority. But the main source of self-governing authority that tribes have to make decisions and implement tribal justices systems is inherent authority.
My name is Lisa Yeager, for those of you who might not know me, and I'm a tribal government specialist for the Tanana Chiefs Conference. And I was asked by the council to take a look at your constitution, the governing document for your tribe, and to look to see if it might need some amendments. Today there are over 230 federally recognized tribes in Alaska. Most all of them have constitutions that describe their governments, and most have tribal councils as the governing body. The councils may have 5 to 9 members and may be called Native Council, IRA Council, Traditional Council, Village Council. There's a variety of names that they may be called, but they're all governing bodies of federally recognized tribes.
And essentially, the tribal government represents the tribal members, protecting its land if it has lands, also representing the interests of our members, which can be essential services like welfare assistance, general assistance, burial assistance, any land issues if the tribal member owns any native allotments, housing needs. It depends on the entity where they're at.
Most tribes will focus on the human resources types of service, things that deal with the family and its stability as well as quality of life. And in our case, we do human services dealing with Indian child welfare, social services dealing with general welfare assistance, TANF, etc. And we also provide educational services both in Head Start and college student assistance program and vocational training.
Although the Alaska Native Claims Settlement Act placed the land with various regional and village corporations, most tribes in Alaska own land. They've gotten this land by purchase, by town site land being transferred to them. Cities sometimes have transferred land, or even large transfers from corporations. This land is owned in fee simple title, meaning the tribe's name is on the deed, and they manage the land for the benefit of the tribe. It's not Indian country for the purposes of jurisdiction.
Jurisdiction means the ability to make your own laws and the authority to enforce them. And so, for example, the federal government will have jurisdiction, and a state government will have jurisdiction, and a tribal government in the same way also has jurisdiction, just over perhaps different things. Now, how people figure out how much jurisdiction they have as a government is usually determined by court cases. And there have been some critical ones in Indian law determining what kind of jurisdiction tribal courts have. The main case that people usually refer to is called the Venati tax case. And in that case, the U.S. Supreme Court said that ANCSA corporate lands were not Indian country for purposes of jurisdiction and other federal statutes. Now, that had some pretty far-reaching impacts. The first is that people misinterpret to this day the holding of Venati to mean that there is no Indian country in Alaska, which is most likely not true. There are millions of acres of allotments and other kinds of lands that would probably be considered Indian country. However, that has not been tested in courts. The second issue with Venati is that after it happened, a lot of people, law review article writers, professors, other lawyers, assumed that without corporate lands as Indian country, that tribes wouldn't have any jurisdiction. But since the Venati case, there have been at least 3, probably a handful of other cases in which the federal courts and the Alaska Supreme Court have said land doesn't matter. Now, sure, you get more jurisdiction if you have land. You get authority over criminal laws and the ability to punish people in certain ways. But even without land, you still have a lot of what is called civil jurisdiction. And civil jurisdiction means you can impose penalties on people or order them to do certain things. And by penalties, I mean financial penalties. You can fine them or order them to do something for something that they've done wrong.
Another case that shed light on the nature of tribal jurisdiction in Alaska was a state one. John versus Baker, decided in 1999. This benchmark case laid out some essential parameters for the relationship between Alaska tribes and the state of Alaska.
The 3 things that I think are the most crucial, one was that Alaska Native villages, those included on the 1993 list of federally recognized tribes as ratified by the 1994 Tribal List Recognition Act, were federally recognized tribes, and state courts had to recognize that they were federally recognized tribes as well. Secondly, that as federally recognized tribes, Congress had never taken away from Alaska Native villages the authority to resolve disputes involving relationships between tribal members. And furthermore, that they retained that authority regardless of whether those villages occupied Indian country or not. And the third thing that they said was that state courts should grant some measure of respect to tribal court proceedings and decrees under a doctrine that the courts refer to as comity, which is another word for respect, and that it was not necessary that the tribal courts conduct themselves in precisely the same way that state courts did. A state court should recognize that tribal courts have somewhat different values, different heritages, and they're likely to have different types of proceedings. It is important, the Alaska Supreme Court noted, that those tribal courts comply with due process, that they have to give the people involved an opportunity to be heard, following notice that tells them how they can exercise that right, and hold their hearings in front of fair and impartial tribunals, and a judge or a panel of judges who don't start out feeling one way or the other about the case. But that as long as due process is accorded, the tribal courts don't have to be cookie-cutter replicas of state courts.
In 2010, the federal courts ruled that Alaska tribes may initiate child protection cases in a case called Hogan versus Caltech. And the Alaska State Supreme Court agreed in 2011 in a case referred to as State versus Tanana. Most of the tribes in Alaska are developing or have active tribal courts and organizing them under a range of structures.
Tribal courts can be anything from informal peacemaking, circle peacemaking, informal preventative decision-making by elders, through formal decisions by tribal councils acting as tribal courts, to even some communities deciding to separate their tribal courts from their tribal council and either electing and appointing tribal judges to serve as decision makers for the tribe.
While courts make common law regarding tribes and corporations, the United States Congress has the primary role in making federal Indian law.
Well, Congress has a significant role because of the unique relationship from a government to government relationship with tribes around the country and in Alaska, that we have legislation in every committee in one way or another touches tribal law, may it be on criminal justice system, may not be on land issues or just the issue of small business, you name it, Congress is a significant part of the equation.
In the Congress, we have committees on both the House and the Senate side that are specifically designed to focus on the issues as they relate to our First Peoples. The Senate Indian Affairs Committee that I have served on since I've been in the Senate is one that looks to all aspects of the laws to recognize that this is a permanent standing committee in the United States Senate. I think speaks to the significance of the role that federal trust responsibility between our federal government and our First Peoples.
And this is Inupiaq Pride. I love my people, representing Inupiaq country.
It's up to us then to find out ways that we can cooperate and work better together to make sure that the tribal interests are looked out for while the corporation does its business.
Well, if we can figure out how best to work with corporations and tribes and try to make them work together, it could be pretty powerful. But until the two like minds decide to work together, it's not going to happen. You know, and that's where we're going to have to find that melding.
I say that as a Native man, I'm willing to, work together with people, work together with various organizations in spite of who has more power than who, and, for one common purpose, to improve the lives of our people.
I think one of the things that ANCSA corporations have not done with their business success is find a way to bring it home to the rural villages. So that's something that we in this generation looking forward need to do better.
I would encourage people to just always be engaged, no matter at what level. I don't care if you're a young person or an elder, just be engaged in what you want your community to be like, and never forget your history and your culture, because that will derive what the future is.
Speak up, because these are laws that are designed to protect, that are laws that are designed to keep our commitment, and if they're not working, or if they need to be addressed, we need to be responsive to that. I have
hopes that the lands that we selected will remain in the Native hands for as long as there are Alaska Natives in the state of Alaska.
Working for our tribe can be a huge commitment and take a lot of dedication, but we need our young people to get their educations and work for their people.
If we raise a bunch of kids, educate them really well on how to deal with law and how to understand ANCSA and everything else, but then we forget to give them that values, that strong spirit inside them, then they might get lost in what they're fighting for.
It's really important for local entities and villages to work together towards a common vision. It's really important, even though we have different governing entities at the local level that all have their own interests and their own roles and responsibilities in villages, for them to work towards a common vision is really important.
What we really want to talk about is what are we going to leave for our grandchildren when all of this is done? And that's the same issue that we cropped up in subsistence. That's why subsistence is so important. That's why the issue of ANCSA and tribal governments are so important. It's never about us. It's all about that group of youth that is still 2-3 generations down the road.